Hi, I'm James Thompson. I'm a solicitor and a partner in the firm of Harrison Solicitors. I'm also the Head of Clinical Negligence department. I'm a director of the charity Little Hiccups, which is based in Leeds, and I'd encourage you to have a look at their website. I'm also the only solicitor in the north of England who's recommended by the Erbs Palsy Group. There are a number of ways of funding a clinical negligence claim, which include paying for it privately, a no-win, no-fee agreement, legal aid for some claimants, trade union, and also legal expenses insurance. Our job is to make sure that we explain these to you in detail before choosing which one is right for you. Public funding, also known as legal aid, is available for children who have sustained neurological injuries at or around birth or shortly thereafter. Only accredited firms can obtain legal aid for the appropriate claimants, and we are one of those firms. Legal expenses insurance is sometimes available on a insurance policy which you already have the benefit of. Often it would be on a household contents or building policy, and we would ask you to bring copies of those in with you because each one is subtly different, and we'd need to look at the detail to see whether or not it provides you with the appropriate amount of cover to pursue a claim. If you're a trade union member or a family member is, sometimes they will provide you with support in pursuing a claim. That can form either paying for it in part or signposting you to a firm of solicitors. One of the other options is to pay for it privately. We would give you an estimate of the total cost of the claim based upon the information available. And it would be for you to decide whether or not that's something which you can afford to do. There are benefits to paying for a case privately, such as not having to meet an insurance premium or pay a success fee. The vast majority of cases which are not legally aided are funded by a no-win, no-fee agreement, or also known as a conditional fee agreement. These CFAs do vary from firm to firm, but the key element which should not vary between the firms is that if the case is unsuccessful, you don't have to pay anything. There are some obligations upon you which you need to comply with to ensure that doesn't happen. These obligations are simple. They are to give us instructions in order to allow us to do our work properly, to not ask us to work in an improper or unreasonable way. Not to deliberately mislead us or anybody that's connected with the case, including medical experts, the opponents or the court, and to attend any medical appointments which we ask you to, and court hearings. With those obligations upon you and compliance with them, you will not end up with a fee from us. In the event that your case is successful, you are entitled to recover your reasonable and proportionate costs from your opponent. If there is a shortfall between the costs which have been incurred and the costs which are recovered, we will not be seeking to recover that shortfall from you. This is one of the terms that will vary from firm to firm. We don't recover the shortfall from our clients because it can form a significant proportion of their damages. It doesn't sit well with us, and we simply don't do it. With conditional fee agreements, there is also a success fee which may be payable. We have produced a standalone article on the website which explains how these work. We've worked through examples of how the success fee equates to the amount of damages which could be deducted from your claim only in the event that it's successful. At Harrison Solicitors, we endeavour to make sure that our clients are entirely confident and comfortable with the funding option which they've chosen. We will make sure that we have given you all the information in advance of meeting with you so that you can go through it at your own leisure and flag up anything that you would like to ask questions about. We will then go through it with you either on the telephone or at a face-to-face meeting at your home or in your office. Again, walking you through the document which will govern the funding option which you've chosen and which we think is best for you, to make sure that you entirely understand everything and are comfortable with it before you sign anything. There is also a cooling off period after you've entered into a retainer, so that if you change your mind for any reason, you can cancel it within 14 days. If you'd like to know more or want to speak to a member of the clinical negligence team, you can call us on 0113 284 5000.